Civil Rules for the Supreme Court and the County Court, Motion Procedures, Section 202.8. All motions shall be returnable before the assigned judge, and all papers shall be filed with the court on or before the return date. So filed with the court on or before the return date and returnable before the assigned judge. Now, there's special procedures for unassigned cases. So if a case has not been assigned to a judge, the motion shall be made returnable before the court. The motion shall be made returnable before the court, and a copy of the moving papers together with the RJI, the request for judicial intervention, shall be filed with the court with proof of service upon all other parties where required by Section 202.6. So if it's unassigned, then they haven't been assigned to a judge. The motion has to be made returnable before the court. So it's the motion and a copy of the moving papers together with a request for the RJI. So actually it's three things. The motion shall be returnable before the court, and a copy of the moving papers with a request for judicial intervention shall be filed with the court with proof of service upon all other parties where required within 5 days of service upon the parties. The moving party shall give written notice of the index number to all other parties immediately after filing of the papers. Copies of all responding papers shall be submitted to the court with proof of service and with the index number set forth in the papers on or before the return date. The case shall be assigned to a judge as soon as practicable after the filing of the RJI, pursuant to Section 202.6 of this part, but in no event later than the return date. After assignment to the judge, the court shall provide for appropriate notice to the parties of the name of the assigned judge. Motion papers notice to be heard in a county other than the county where the venue of action has been placed by the plaintiff shall be assigned to a judge in accordance with the procedures established by the fucking chief administrator. I do not think they're going to ask that, but I would definitely know that the unassigned cases, if it has not been assigned to a judge, the motion shall be made returnable, and a copy of the moving papers together with the RJI shall be filed with the court with proof of service within 5 days of service upon the other parties. That's what I would know. And the moving party shall give written notice of the index number to all other parties immediately after filing of the papers. Okay. And that the case shall be assigned as soon as practicable after the filing of the RJI. Okay, so the moving party shall serve copies of all affidavits and briefs upon all other parties at the time of service of the notice of motion. The answering party shall serve copies of all affidavits and briefs as required by CPLR 2214. So now, CPLR 2214, it has to do with the time that the motion has to be filed within. So we have 2 time frames for that. CPLR 2214 is 16/7/1 and 8/2. I always say 0. Okay, so the 16 days is the motion has to be filed 16 days before the return date. Now, if they're going to have an answer, the other side is going to oppose the motion, they're going to have an answer, that's going to be 7 days. And then if the person who put the motion in place is going to respond to their answer, they have 1 day before the return date of that motion. The same thing goes with 820. If the person putting in for the motion has the return date 8 days before the return date, then the other side has 2 days to file an answer, and then if the other party wants to reply, they'd have to reply on the return date. That's why I put 0. So that's what CPLR 2214 is for anybody, and I hope that made sense, because sometimes I don't know if I make sense. Okay, so this also says affidavits shall be for a statement of the relevant facts, and briefs shall be a statement of the relevant law. So again, affidavits shall be for a statement of the relevant facts, briefs shall be for a statement of the relevant law. motion papers received by the clerk of the court on or before the return date shall be deemed submitted as of the return date. The assigned judge, in his or her discretion or at the request of a party thereafter, may determine that any motion be orally argued and may fix a time for all oral arguments. So, what I was talking about with those time frames, with the 1671 and the 820 for the times to respond, that what I'm talking about is writing, in writing. They put a motion in writing, the other side puts an answer in writing, and then the other side, if they wanted to put in a reply, would be in writing. So now this is at the discretion or at the request of the party that they can determine that any motion be orally argued, which means that they would come into court and it would be on the record. The party would make their motion on the record in the courtroom, and the other side would put their answer or their reply, whatever it is they're opposing, on the record, and then the judge would render a decision and an order on the record. A motion is always put in for the judge to make a decision and ultimately to render an order. Render a decision and to make an order. So that's what a motion is for. A motion is to get an order by the court. A party requesting oral arguments shall set forth such request in its notice of motion. So once they put a notice of motion, if they want it to be sent orally, they would have to put that in writing. Or in its order to show cause, which we know an order to show cause is a speedy motion, or on the first page of the answering papers as the case may be. Where all parties to a motion request oral arguments shall be granted unless the court shall determine it to be unnecessary. So I don't know what the fuck that means. Where a motion is brought on by order to show cause, the court may set forth in the order that oral argument is required on the return date of the motion. Stipulations of adjournment of the return date. Now, I think this is important to know for the test because I feel like it was somewhere. Stipulations of adjournment of the return date made by the parties shall be in writing and shall be submitted to the assigned judge. Such stipulation shall be effective unless the court otherwise directs. Now, this is a part I think that everybody should know. No more than 3 stipulated adjournments for an aggregate period of 60 days shall be submitted without prior permission of the court. Absent agreement by the parties, a request by any party for an adjournment shall be submitted in writing upon notice to the other party to the assigned judge on or before the return date. The court will notify the requesting party whether the adjournment has been granted. Where the motion relates to disclosure or to a bill of particulars and a preliminary conference has not been held, the court shall notify all parties of a scheduled date to appear for a preliminary conference, which shall not be more than 45 days. Again, this is different. So, preliminary conference relating for a motion relating to disclosure, bill of particulars, and a preliminary conference has not been held. The preliminary conference shall be not more than 45 days from the return date of the motion unless the court orders otherwise. See, this is orders otherwise. And a form of a stipulation and order prescribed by the fucking chief administrator of the court shall be made available, which the parties may sign, agreeing to a timetable which shall provide for completion of disclosure within 12 months and for resolution of any other issues raised by the motion. If all parties sign the form and return it to the court before the return date of the motion, such form shall be so ordered. And that's in quotes because really it's just the judge signing it. By the court, and the motion shall be deemed withdrawn. If such stipulation is not returned by all parties, the conference shall be held on the assigned date. Issues raised by the motion and not resolved at the conference shall be determined by the court. Unless the circumstances require settlement of an order, a judge shall incorporate into the decision an order affecting the relief specified in the decision. Reports of pending motions in Supreme Court. Okay. 1. To assist in preparing the quarterly report of pending civil matters required by Section 4.1 of the rules of the chief judge, the fucking chief administrator of the court, or his or her designee shall provide to a justice of the Supreme Court upon request an automated open motion report of all motions pending before the justice which appear undecided 60 days after final submission. And that 60 days rule is in there because after a motion is submitted for a decision from a judge, the judge has 60 days to decide the motion. So that's why it says that they want to do these reports now so that the judges know that they're come past the time for their 60-day mark, that they should have a final decision and render and have an order for the for both parties on the motion. This open motion report may be used by the justice to assist in the preparation of his or her official quarterly report. Such motions are decided on a daily basis, and further submissions may be received on a pending motion. The only report that shall be considered current is the official quarterly report submitted by the particular justice. So there's some time frames in here that I just want everybody just to be aware of, because on they seem to like time frames. So in the first part of unassigned cases, on an unassigned judge, we have a motion returnable before the court, copy of the moving papers, RJI, filed with the court with proof of service within 5 days. For a decision from a judge, the judge has 60 days to decide the motion. So that's why it says that they want to do these reports now so that the judges know that they're come past the time for their 60-day mark, that they should have a final decision, have an order for both parties on the motion. The case shall be assigned to a judge as soon as practicable after the filing of the RJI. That's another one. The other one that's important is if a motion relates to disclosure to a bill of particulars and a preliminary conference has not been held, the court shall notify all parties of a scheduled date to appear for a preliminary conference, which shall be not more than 45 days from the return date of the motion, unless the court orders otherwise, and a form of the stipulation and order prescribed by the fucking chief administrator. The timetable, which shall provide for completion of disclosure within 12 months. Provide for completion of disclosure within 12 months. Completion of disclosure has to be done within 12 months. And then the other time frame we have is that the report, upon request, an automated open motion report of all motions pending before the justice which appear undecided 60 days after the final submission. And that's it.